Yes, Ms. Kitts.
My Lord, I believe it was my Lord Burroughs who had asked about the evidence in relation to 90% of the calls going to Digicel.
I think it was Lord Kitchen, actually, but either way.
Far away, yes, thank you.
Page 1001. This is the evidence from, I'm so sorry, 1001. This is the evidence of Mr. Robinson before Justice Batts.
Yes.
And he says, majority of calls the overseas carriers sent through to you are destined for Digicel. Then he said, no. Up to last year, 90% to cable and wireless, but service went bad. I had to stay a line and go to Digicel. Then he says, it is dynamic. At this moment, 90% of the calls have been going to Digicel.
Yeah. Thank you.
The Court of Appeal made a finding in relation to this at 1187.
Yes.
Yes?
Well, that does the job, doesn't it? That's paragraph 13.
That is so, my Lord.
Thank you.
Now, I believe I had also indicated to your lordships that it was only on an order made some 2 or more years later that the tax was paid on the deposit. And that is to be found at EB 1491. You will see the formal order of my Lady Sinclair Haynes on the 10th of May 2016. On an application for a stay which was refused, she ordered that he pay the applicable deposit on or before the 24th of May. And it is agreed that it was paid, my Lord, on that date. So what we say, my lords, in the round is that contrary to the assertion that the issue as to whether it was reasonably foreseeable or it was an issue that arose at the outset, that there was possible loss to cable and wireless if this injunction was granted, we say that the evidence which is before this court of what took place before my Lord Brown when he granted the order shows that that is not the case. That it was known by Mr. Robinson, it was asserted by Cable and Wireless, and it certainly was before the court when the court granted that mandatory order that loss was likely to happen if that tax wasn't paid. In that affidavit, she said 10 million within 3 months.
And that is just to be clear, that is the tax on not the deposit, but the tax on the calls.
On the calls. So she was saying if the tax isn't paid on the calls, then Cable and Wireless has to pay the tax, and we are going to be out of pocket constantly.
Can I just clarify on the order you've just shown us of page 1491?
Yes, my Lord.
Where it says that the applicant is hereby ordered to pay, quote, the applicable deposit. How much was that?
At that
well,
time.
was it the deposit plus 70% of the TCT or 100%?
Well, at that point, my Lord, it would have been 70.
Yes, okay. Yes.
The bare 3-month charge had been paid pursuant to the order of my Lord Brown.
All right.
From 2 years before, in August when he gave the mandatory order. I will show
So
you, my
it's
lord.
just the 70% TCT.
That was being ordered to now
Okay.
be paid.
All right. Thank you.
And what my Lord Batts and the Court of Appeal found was that in those circumstances, Cable and Wireless was under no obligation to turn on that switch when the tax had not been paid together with the deposit. And that finding is made by my Lord Batts between paragraphs 50 and 57, or in paragraphs 50 and 57 of his judgment, EB 064, is it? I'm so sorry, my lords. Let me just check that. If it is 0, I might have the wrong. It is 10, my lords. 1064. In fact, it appears to me that I need to backtrack there, my lord. 1061, paragraph 50. My Lord Batts, having found that the claimant does not provide telephone service in Jamaica, he says it's manifest, and does not terminate calls in Jamaica, the tax is therefore not payable to the Commissioner by the claimant. The Commissioner of Taxes, for reasons of convenience and accountability, has decided to impose the special tax on incoming international calls on the telephone service provider who terminates the call. And then he goes on, insofar as the first and second issues are concerned, I find in the defendant's favor. The defendant was not obliged to turn on the switch until and unless the claimant paid the contractually agreed deposit. That deposit was to be a pre-estimate of 3 months usage charge. Usage charges include any applicable tax. The defendant therefore failed to pay the requisite deposit. And in 54, my lord, I'm so sorry, 57. In 57, on page 1064.
Well, yes, 56, I think, perhaps you.
From 56, my lord, yes. He starts at 56, that is so, thank you, my lord. In the matter at bar, however, the words are clear and their effect creates no absurdity, injustice, or manifest inconvenience. I therefore hold that in computing the deposit, the defendant was obliged to add the applicable tax with a 30% reduction in respect of the exemption. The claimant, as I found, failed to tender the properly computed deposit. This means that the defendant was not obliged to turn on the switch. The said payment being a precondition to interconnection, the claim therefore fails.
Can you just pinpoint what the precise reasoning there is in relation to the clauses of the contract? When it said it's a precondition, are we looking at clause 24.4? Because there's all this stuff about, well, you've got to carry on with your obligations if there's a dispute up to a certain amount and so on.
Yes, my lord.
So what is it that makes it absolutely clear that...
Is it clause 3.1?
I'm at 42 of... Yes.
Isn't it 28?
28.2, my Lord Batts refers to it in 42 of his judgment, page 1056, paragraph 42. He quotes from clause 28.2 of the interconnection agreement.
I think it's read with clause 3.1.
Yes.
Yes, my lord. And in addition, it's read with clause 9.7, which is the one which speaks about the applicable taxes. So in 44, in paragraph 44, on page 1058, his last sentence reads in that paragraph, to the extent, therefore, that the charges levied include any tax payable It certainly was within the party's contemplation and reflects to my mind a correct construction that the computation of 3 months usage charge includes any tax payable in accordance with clause 9.7 quoted above.
Yes, but sorry, I'm still struggling.
Yes, my lord.
Why a non-payment of the security entitles the CWJ not to continue with the contract? Where do we actually get that, given that there's all these clauses in clause 24 about failing to pay, invoices, etc., don't necessarily give rise to termination? Is it just that we're interpreting this as an obvious condition before any of this starts?
It is
the word subject to clause 28
Yeah.
3.1.
3.1.
So that
3.1.
the express obligation to turn on the switch is subject to clause 28.
That is so, my lord.
Right, thank
It's
you.
really about termination of the contract, as I see it. It's all about turning
Oh,
on the
okay.
switch.
It's about turning on the switch so that the service can be provided.
Yeah.
And what was plain was that Cable and Wireless was saying, until you pay me the appropriate deposit, I'm not going to turn on the switch.
Well, I just wanted to ask you about that. Cable and Wireless were saying, until you pay us the appropriate deposit, we won't turn on the switch. But Cable and Wireless was saying that the appropriate deposit included 100% of the TCT,
It was saying that, my lord,
and it was wrong.
and it turned out to be incorrect.
So, with the obligation under 28.2 is, I mean, it's for Cable and Wireless to require telco to pay a deposit.
Yes, sir?
So, it would look as if what triggers the obligation to pay is a requirement to pay a specified amount by way of deposit. I mean, what 28.2 says is that it's for that Cable and Wireless may require telco to provide an initial security deposit, and then it goes on to say the amount of such deposit shall not exceed the sum of 3 months usage charges. The expression, the use of the word shall not exceed the sum of, gives to Cable and Wireless the power to ask for a lesser amount.
It does, my lord.
So it's for Cable and Wireless to specify the amount it wants, but it cannot exceed 3 months usage charges. Do you agree with that?
I would agree with that, my lord.
But they specified too large a sum.
As it turned out.
So in those circumstances, what was the obligation of Traille?
The obligation, my lord, of Traille would have been to pay at least the sum that they say was due. They have not paid either 100 or 70. They paid no tax at all. So what you have here is a circumstance in which Cable and Wireless has provided a service. The government is collecting from Cable and Wireless a tax that the government says is due in a particular way. And Traille has not even paid what it said it ought to have paid. Because, my lord, if Traille had paid the 70% together with the tax, Cable and Wireless would have lost this claim because the court would have found
Cable and Wireless still wouldn't have switched on if they had paid 70%.
We don't know that. Still finding about that.
yes. Well, my lord, there may have been, though, an order, just as an order was made for them to switch on when 0 was paid, you could have had an order which was given in those terms if 70% was paid. Because, my lord, what we know is that in his application, Mr. Robinson's affidavit was clear that he was to pay nothing at all to Cable and Wireless.
By way of the tax.
By way of?
The tax.
the tax. He was to pay no tax at all.
That was his stance.
That was his stance.
And presumably Cable and Wireless's stance was, we're not going to turn this on unless we get 100%.
That is so, my lord.
Right, thank you.
So if I may continue, in response to my learned friend's summary, my learned friend says there was no specific finding that the interlocutory injunction was incorrectly obtained. And in fact, the courts below upheld the Traille's contention that if the TCT were to be included in the deposit, it would be limited to 70%, and CWJ had refused to accept that reduced figure. Accordingly, since Traille was willing to include 70% of the TCT on the deposit, and CWJ was unwilling to accept that reduced figure, then Traille was entitled to the interlocutory relief, and CWJ was not entitled to any damages flowing from the grant of that relief. That is what is my learned friend's submission on this issue. And we, my lord, reiterate the finding of my lord Batts, in which he said that the defendant was not obliged to turn on the switch since the correct deposit had not been paid. So what my lord Batts finds is, I have said it was 70%, but they haven't even paid the 70% that they were asserting was due. Therefore, Cable and Wireless was not obliged to turn on the switch, because had they paid that 70% and not turned on the switch, and Cable and Wireless not turned on the switch, then the outcome would have been different, in my respectful submission. The Court of Appeal treated with these sections in paragraphs 94 to 120 of the judgment. And my lords, I would therefore take you to...
Just before we leave that point, I think the point put against you is that they were trying to pay 70%, but the CJW wouldn't accept 70%.
Well, my lord, they were not trying to pay it, I would suggest, because they did not do so. They did not even tender it. When you look at the emails that were exchanged, what we see is a postulation on the part of Traille. And in fact, when we look at his affidavit before the judge, he doesn't say there, I'm prepared to pay 70% for this to be put to rights. He says, I am to pay my tax to the government myself. And I would remind your lordships of
That's in the affidavit.
That's in the affidavit, madam.
Yeah, yes, I see.
Yes. He doesn't say there, I am to pay 70% and I'm prepared to do so. He says he is to pay his tax to the government directly. He says in paragraph...
It's a fair inference that if the ambit of the dispute for the Mr. Justice Brown, is it Mr. Justice Brown?
Brown, my lord.
Had been 70% or 100%, he would have ordered 70% to be paid as a condition for the injunction.
Certainly, my lord. But he only said pay it without any tax at all.
Yeah.
And that is because what was being urged on him was that it should be paid without any tax at all. Because Traille should pay its tax itself.
Yeah.
And when you look at paragraph 24, in that affidavit, 1463...
1463.
That is so, my lord.
Yeah.
Claimant does not agree that the law states that the defendant should pay the claimant's monthly call tax.
Yeah.
So he was not at all saying here, I'm to pay 70%. He contends that the law states that 30% is exempted. He says this, and he refers to it. But at no time does he say, I am to pay to Cable and Wireless and they pay to me. So that would have been the context of the judge's order.
Just remind me of the relevant dates. The emails that your opponent was relying on were dated April of 2014, and this affidavit is
August, my lord.
right. Thank you.
Sorry, I'm so sorry, my lord. The 11th of July, 2014 is Mr. Robinson's affidavit.
This is the one we're looking at, is it?
This is the one we're looking at.
In a way, the crunch point is the hearing.
I beg your pardon, my
The
lord?
crunch point would be the hearing before the judge, although we don't, I think, have a record of a transcript of the submissions made.
No, my lord.
No.
Of what was before my lord Brown.
That's what I mean.
Yes, my lord. There is no, but this was what was before my lord Brown, as well as the affidavit of Miss Simone Winter.
It does go on in paragraph 24 to say if the claimant is wrong,
Yes.
then it's 30% should be exempted. So
He does say that, my
our
lord.
point was there at any rate.
Yes.
So he says this was communicated, but to the defendant, and they have indicated that they are following the technical notes and not the
Yes.
gazetted law. That's what he says.
But he must have found that there was an arguable case that they didn't have to pay any tax at all, was it?
That certainly was the determination of the judge,
Yeah.
that no tax at all
Yeah.
should be paid. Because the order, my lord, says it expressly. And in fact, in cross-examination, Mr. Robinson repeatedly said that he didn't pay any tax because that's what the judge said. And that can be seen on page 1002. Where the question is asked,
This is Mr. Robinson, is it?
Mr. Robinson's cross-examination,
Yes.
my lord, on 1002.
Yeah.
So the question is, Digicel adds to the usage charge a special telephone calls tax on each call? He says, no, Digicel should not be. Is it a fact that Digicel adds a special tax to the usage charge? No, they add only GCT. To the charge per minute for each call, they add a special telecommunications tax. I don't know. I suggest that Digicel adds tax for each minute of calls sent through their network. Very unfortunate. Lime charged you the tax on each invoice. I told them the court says they should not do it. Have they invoiced you with the tax on each? Yes, they have. Now, would you agree that all Justice Glenn Brown ordered was that the deposit should be paid without a tax? I don't agree. When he spoke to us a question, he asked the order.
So we're talking here about the invoices, are we?
Well,
The
we're
monthly invoices.
yes, but what we're talking about here, my lord, is that he was of the view that Justice Glenn Brown approved the payment without the tax
Of the monthly invoices.
of the monthly invoices. And so he was saying Cable and Wireless should not be invoicing monthly.
Yeah. That's 1003.
Yes,
Be billed for the tax every month. You haven't paid it as per the court order.
that is so, my lord.
No.
So, in fact, this informed Justice Batts's view of the matter, that the Traille felt fortified by the order of Justice Batts that they need not pay the tax.
Justice Brown.
I'm so sorry, by Justice Brown, that they need not pay the tax. The Court of Appeal viewed it somewhat differently, but came to the same conclusion, that Justice Batts's discretion could not be challenged in the circumstances. So what the court said, my lord, in paragraph 117 at page 1226. This is the Court of Appeal. And perhaps I should have started prior to 1224, going back a bit to 1225, where at paragraph 112, the court speaks to the general principles that it will not lightly disturb a decision, the exercise of the discretion on the damages flowing from the grant of an injunction. And they cite Hadmore and Smith and Day. And then in 113, Dr. Barnett's criticism of Justice Batts' exercise of his discretion cannot be supported. He has not shown that the learned judge was plainly wrong. First, it has been proved that Traille was not entitled to the injunction. Justice Batts found that Cable and Wireless was not obliged to turn on the switch until Traille had paid the deposit. The fact that Cable and Wireless claimed an incorrect amount as a deposit did not affect that position. That issue has been assessed above, and it has been pointed out that Traille did not tender the amount that Justice Batts ultimately determined to be the correct figure. Secondly, Justice Batts found that Traille's claim had failed on the merits. The consideration of its undertaking as to damages arose as a consequence of Cable and Wireless' assertion that it incurred loss as a result of the injunction. Among the orders made by Justice Brown were that Traille was to pay the deposit to Cable and Wireless less the tax, and upon receipt of the stipulated deposit, Cable and Wireless should turn on the switch to facilitate the interconnection. And this paragraph now, my lords, although it is true that Justice Brown's order did not mention the issue of telephone calls tax on monthly invoices, the natural and probable consequence of Justice Brown's grant of the injunction was that billing would flow from Cable and Wireless's turning on the switch. The fact that Justice Brown ordered that the calculation of the deposit should not include TCT did not implicitly mean that monthly invoices should not include TCT. Justice Batts, however, found to the contrary. He said at paragraph 59 that implicit in Justice Brown's order was that tax was not to be included on the monthly invoices. He cannot be said to be correct on that finding. The inclusion of tax on the monthly billing constitutes a different dispute. The OUR had already ruled that Cable and Wireless was responsible for paying over the tax. It was therefore fair and reasonable for Cable and Wireless to have done so. That expenditure by Cable and Wireless would weigh in its favor in any consideration as to the ordering of an inquiry as to damages. And he goes on, and then he says in 119, my Lord Brooks, such was the evidence before Justice Batts for him to exercise his discretion whether to enforce Traille's undertaking as to damages. At paragraph 59 of his judgment, he exercised that discretion and ruled that Cable and Wireless was protected by Traille's undertaking as to damages, to which Cable and Wireless may have recourse, given the final determination of these issues. In these circumstances, Justice Batts cannot be said to have been plainly wrong in exercising his discretion. Traille must fail on the grounds in respect of this issue. So, my lords, we say that even if the court disagreed with Justice Batts as to the basis for finding that the injunction, that there had been no breach of the contract by Cable and Wireless, and therefore they were entitled to refuse to turn on the switch. In those circumstances, the Court of Appeal came to the same conclusion, that Justice Batts was correct in finding that the claim by Traille failed, and therefore damages flowed from the grant of the injunction which caused the switch to be turned on. So having found, my lords, In the same way as Justice Batts, it is our submission that there are concurrent findings on this issue which have not been challenged appropriately by my learned friends.
So the injunction was wrongly granted because they were not obliged to turn the switch on,
That is so, my lord.
and a loss which has flowed from being required wrongly to turn the switch on has been their inability to recover the tax or the loss that they've suffered
The loss
through
that they
having
suffered.
through being required to account for the tax.
That is so, my lord.
Is that right?
That is what we're saying. And in this case, what we sought to recover was interest on the money which had been expended.
Because when the tax authority credited you with the tax paid by Traille, they didn't credit you with interest.
They wouldn't credit us with interest. So the $60-odd million that had been spent over that 2-year period, naturally, the loss of use of those funds resulted in loss to Cape and Wireless.
It is a slight oddity, isn't it? That,
I beg your pardon, my lord?
it is a slight oddity that all of this is triggered, so to speak, by the failure to pay the deposit, but the loss that has in fact been suffered on, and for which you claimed on the cross undertaking, was the loss being the cost to you in the interest payments in respect of the tax for which you hadn't got the credit.
That is so, my lord, because the claimant's representative said clearly that he refused to pay the tax because it was not to be paid to Cable and Wireless. So he said it was wrong for them to give me an invoice with the tax, and so I refused to pay them the tax.
And that was because of the consequence of the
Injunction.
injunction.
That was as a consequence of the injunction. Because had the injunction not been granted, there would have been no switch, there would have been no traffic, there would have been no tax.
Well, that's a sort of sine qua non sort of. I'm sorry, with that. Sine qua non sort of causation. But it may be that something a little more solid than that is required in this context.
But their case was, it's implicit in Brown J's order that no tax is paid on the monthly invoices.
I beg your pardon, my
Their
lord.
case was, it's implicit in the order that no tax is payable on the invoices.
That is so, my lord. No tax is payable on the invoice.
And that's why they
And
didn't pay tax.
That was their evidence before Justice Batts, that they didn't have to pay the tax because Justice Brown said I didn't have to pay it.
On an interim basis. On this is on the basis that the rights haven't yet been finally resolved between the parties. So
The rights had not yet been finally resolved.
And so-
when the rights come to be resolved before Justice Batts, he finds that the tax ought to have been paid to Cable and Wireless. So certainly, in those circumstances, the damages flow as a natural and probable consequence, we submit, of the order to turn on the switch.
Yes. Could I just, there was a point you made that, that the Court of Appeal affirmed the exercise of discretion
Yes.
by Mr. Justice Batts to order an inquiry as to
Damages. Yes.
But I mean, I'm not sure that there's any challenge, as it were, to that decision, is there? I mean, on the assumption that Cable and Wireless was right. I mean, the determination of what losses flowed from the injunction was left to Mr. Justice or Mrs. Justice Lang. Yes, yes. So the discretion, I'm not sure there's much terms on the discretion.
Well, the discretion to order the inquiry,
Yes,
flowing from the finding that,
yes.
so
I mean, really, that's not. I mean, if once one finds that the injunction was wrongly granted, then I mean, there's no, in one sense, no reason why an inquiry as to damages shouldn't be ordered.
that is so.
The issue then becomes, what loss did flow from the grant of the injunction. That's not something that Mr. Justice Bax decided.
That was Justice Leng, and we go
Yes.
on to that, my
Yes.
lord. We go on to
follow.
Justice Leng's
Yes.
order. So, my lord, when we treat with the issue of damages as found by Justice Leng, I would take you to our paragraphs 83 to 105 in our case. That's starting at page 1561, my lords. So, the inquiry, my lords, that took place before Justice Leng, we say that there was no dispute that the injunction having been granted, the inquiry was ordered accordingly. And on the 5th of May 2017, Justice Leng conducted that inquiry. And what he found was due was $1.415 million, which was a shortfall of the tax paid by Cable and Wireless as against that paid by Traille. Shortfall of the tax that paid by Traille as against that paid by Cable and Wireless. And then there was interest on $65.9 million, which totaled $20.5 million. And he ordered a per diem interest rate until the judgment was paid. Now,
Yes, can you just, the figure of 65.9 was brought down from an earlier figure of 73.2. Something to do with a dispute about one particular monthly payment. Is
Yes.
that right?
yeah, my lord, the Cable and Wireless agreed to not charge for 1 month at the end of my lord Bax's decision. So
Right.
it was
March,
that is.
something or other. Yeah.
That is so, my
Correct.
lord. It was a decision taken not to charge for every single month, not to seek
Yeah.
every drop of blood, so to speak. So that amount, my lord, was the principal amount of the tax paid less that month, and interest was calculated on that amount. And what we say is that my lord Leng made no error in the manner in which he awarded the interest. He took into account, in accordance with the principles of Smith and Day and Hoffman-LaRoche, he took into account the fact that the damages were due to be enforced, and he then applied not the rate which comprised the interconnection offer, which the interconnection agreement, which actually turned out to be a larger amount if it had been applied, but he applied the rate of commercial interest as determined by the Bank of Jamaica's Statistical Digest. So, in fact, my lords, that was his indication to counsel, because it had not been brought by either party to him. The submission had been that he should calculate the interest in accordance with the rate in the agreement, but the judge asked us to go away and recalculate it using the Bank of Jamaica rate. And in paragraph 94 of our submissions on page 1564, we say that.
So this is Bank of Jamaica lending rate plus 2%, base lending rate plus 2%.
Commercial rate, yes, ma'am.
Yeah. And in the agreement, it was the Bank of Nova Scotia, is
It was Bank of Nova Scotia, my lord. So
Yeah, and that would have been higher, marginally higher.
the Bank of Nova Scotia was marginally higher
Right.
than the Bank of Jamaica's average, weighted average lending rate or commercial rate.
And I think a point put against you is, well, when you're claiming interest as damages, normally you have to plead specifically. Now, what do you say to that?
Absolutely not, my lord. We do not agree with that submission. This was, in the inquiry as to damages, affidavits were filed by Simone Winter, in which she set out a computation based on the agreement, because, my lords, what we have in the interconnection agreement is a provision that says if monies are not paid, it will incur interest at the Bank of Jamaica rate plus 2%. So that information was provided to the court, and the court requested that the parties submit to him on a rate derived from the Bank of Jamaica Statistical Digest, as has been approved in several judgments of our court.
You have a reference to the
We've ref-
affidavit evidence.
We've referred to the affidavit evidence.
Do you have a reference for it?
Oh, I'm so sorry, my lord, I will.
You can come back to it. Just
in the in paragraph 94, my lord, on page 1564, we see where Justice Leng noted that he had invited the parties during the currency of the inquiry to reformulate the claim on this basis, instead of on the contractual provision in the interconnection agreement, which would have yielded a higher interest award to the respondent. That is 17.75% per the agreement, as against the 16.12 per the Bank of Jamaica rate. And indeed, we have enumerated the sundry cases of our court, the British Caribbean Insurance Company and Delbert Perrier, which I believe my learned friend, Dr. Barnett, was part of, the Goblin Hill case, the Theophilus MacLeod case, the Jamaica Flour Mills. All of these, my lord, are cases in which the court has upheld, the Court of Appeal and other courts have upheld the submission to the court of the digest from the Bank of Jamaica to provide the appropriate rate of interest in such commercial matters. And so we reference that in paragraph 94, my lords. So we say that, bearing in mind the authorities which are cited, there is no need to plead separately on another document the rate that is sought. We say that the rate was provided for in the agreement, and the judge asked for another rate, and it was therefore the basis of the finding.
Her affidavit states that.
And
No.
he said there was no prejudice to the other side.
Absolutely no prejudice. There could not have been, my lord. Now, the affidavit of Miss Simone Winter.
1068.
Please look with me, my lords, at page 1068 of the bundle.
Can I just be clear? I mean, in an inquiry as to damages, you wouldn't have pleadings anyway.
We would.
So we're purely dealing, are we, with affidavits put forward?
As to the loss. That is so, my lord.
Thank you.
So in fact, what was before my lord Leng was my lord Bats's judgment, and in fact, the record of what was before my lord Bats. And then these affidavits, my lord, which you will see that on page 1068, Ms. Winter indicates that she's referring to her previous witness statements filed in the action. She refers to the order of Justice Brown forcing Cable and Wireless to turn on the switch. She then goes on to the trial of the matter. She refers to the fact that since the trial, Cable and Wireless has been forced to continue paying the tax, even up to March 2016. She says that in paragraph 6. And then she goes on, my lord, on page 1070, in paragraph 8, to indicate what is the base lending rate from the Bank of Jamaica.
From the Bank of Nova Scotia.
Sorry, the Bank of Nova Scotia. I do beg your pardon, my lord. She cites the provision in the agreement 9.6, which indicates that the charge would be done in that fashion. And then we have an affidavit of Mr. Robinson. And I think there was a further affidavit of Ms. Winter in which she recalculated the figures, my lord. Which is to be found at page 1090. Exhibits the Bank of Jamaica statistics, and she shows the adjustment in her calculation using the Bank of Jamaica statistics. And those follow behind her affidavit, my lord. And in the Court of Appeal,
This was
my lord,
after the invitation of the judge.
I beg your pardon?
After the invitation of the judge.
After the invitation of the judge,
produces the-
that was done.
Yeah.
My lord Leng asked the parties, and he indicates it in his judgment. And his judgment, my lord, is in the record. Page 1133 through to 1145.
Yeah.
So, I believe, my lord, you will find at paragraph 30 on page 1144. He says that, in my view, in circumstances such as those under consideration, the court, in assessing the true loss of the defendant, is conducting an exercise similar to that of a court assessing the loss of a plaintiff being kept out of money. In this exercise, the court ought to adopt a similar approach as would a court compensating a plaintiff's loss for award of interest. And he references the Tate and Lyle judgment there. So, my lord, we certainly say that this was an appropriate calculation of the damages. The claimant was not prejudiced by the same. And the Court of Appeal approved that in its judgment. I don't know if I can just locate that quickly, my lord. The Court of Appeal.
1140.
1140. 1140, my lord.
What's it? You- That is just.
No. Justice Lang was 1140. My lord, the provision, the extract which deals with the undertaking by the Court of Appeal, or the interest calculation, is to be found between pages 1217, where the court analyzes a number of cases, including Smith and Day, and Cheltenham and Gloucester Building Society.
Can you give me that page again? I'm sorry.
So it starts, my lord, at 1217.
Oh, yes, thank you.
And it goes through
Yes.
a number of pages. At 97, the court says, Justice Lang's award, after conducting the inquiry that Justice Batts ordered, is for the interest and for the short payment to which he found Cable and Wireless was entitled. And then there is significant argument, my lord, continuing, or recognition of the arguments by Traille and Cable and Wireless. So he goes through paragraphs 98, 99, and finds that the sum found was due. I do not think that much is made in relation to costs, but I certainly would argue that the orders for costs made ought to remain. I take it, my lord, that bearing in mind that my learned friend had indicated that he wasn't challenging the constitutionality of the Validation Act, that I need not treat with it extensively, but we have addressed it in some detail in our written submissions, that the Validation Act having been passed in 2017, all the tax collected by Cable and Wireless, by Digicel, was properly collected and paid over to the revenue. And we have cited the decision of the board in Lower Lawrence, which treats with similar legislation. So, my lords, I think paragraphs 96 to 98 at EB 1218 and paragraph 112 at EB 1225 is where the Court of Appeal concurs with the decision of my Lord Lang.
I'm not sure that's right.
Not sure that's right, my Lord. I could be
I've
wrong.
got a feeling the Court of Appeal starts to deal with this with Mr. Justice Lang's judgment at the foot of page 1229. I think they're still
1229.
dealing with Mr. Justice Batts at the part you referred to.
Thank you, my Lord.
It is confusing because there's similar sort of
They
subject
are
matter.
treating with
Exactly.
all of it together.
Yes.
The right to the inquiry and the inquiry itself.
Yes.
That is so, my Lord.
Yes.
So in those circumstances, we certainly say that the court in the round found that the inquiry's damages was properly ordered and the inquiry that took place was proper in the circumstances.
While we're on page 1232, which is dealing with the appeal from Mr. Justice Lang's judgment, issue 12, the judge erred in allowing Cable and Wireless to bring in further evidence. Is that a reference to the evidence relating to interest? or some other evidence?
I'm so sorry, my lord.
Ground 12.
1232?
Yes, ground 12, the appeal.
Oh, yes, my lord. That is dealing with, my lord, Justice Lang's direction that the parties go and submit to him on the basis of the Bank of Jamaica.
Right, and then that ground was abandoned.
Well,
I think we learned later on. But
I am not entirely sure. It was abandoned? Yes. Oh, it appears that it was abandoned. I do apologize, my lord.
as you see at 1243, paragraph. Well, it said it wasn't argued.
It wasn't argued. It wasn't argued, my lord.
1963, yeah.
So I would never presume that my learned friend abandons any argument. So certainly, my lord, it was my lord Lang's direction that would have been treated with at that point. So, my lord, there is also the issue of mitigation, which my learned friend raises to say that Cable and Wireless ought to have mitigated its loss by, I guess, not paying the tax. What the judges found was that Cable and Wireless made repeated inquiries from, firstly, Mr. Robinson, for proof that the tax was being paid. And you will see in EB, I believe it's 99, you will see in EB 99, my lords, where in fact it starts, my lord, at the bottom of 100, EB 100, where you will see Mr. Robinson writing to Cable and Wireless's Janice Brown. Hi, Janice. As per instructions, I pay my special telecoms tax to the government of Jamaica. USF payments also made. She says, thanks, Rory. It is important that you send us a copy of those payments to update our records. Unless Lime is in receipt of those payments, is in receipt of something is cut off, those payments are deemed outstanding and can result in the suspension of your account as per contractual arrangement. And he says, I beg your pardon, Janet, you have no right or authority to invoice me for special call tax. Much less, I'm not so sure, my service for it being outstanding.
To suspend.
Much less to suspend my service for it being outstanding. Please let me have a peaceful week. Please let us have a peaceful weekend. God be with you. And then she writes back to say, there are outstanding amounts on Lime's books for special call tax and the USO. As per ministerial order, non-payment of either of these charges is a clear breach, and Lime has the authority to suspend. As requested, kindly send a copy of payments for these charges to update our books. Janice, I don't know what you're talking about. These ministerial orders are not presented appeal court, or must have been not presented to the appeal court or the Supreme Court that gave specific instructions. I will not be sending no such copy to you. Supreme Court did not give me or Lime any such instructions. If you want confirmation of payment, the relevant authorities can confirm. So what you had here, my lord, is an attempt to get the information from Mr. Robinson. That did not succeed. And over the leaf at 101, you will see where Cable and Wireless wrote to the Commissioner General, trying to find out if these taxes have been paid. And no response. A further letter, January 30, 2015. So that was December and then January. Referring to that December letter, seeking the guidance of tax administration in relation to the refusal of Traille to pay the special call tax directly to Lime. And a copy of the letter is provided. And what happened, my lord, was that no information was provided from the commissioner. So in such circumstances, Cable and Wireless, having tried to get the information from the customer, from the commissioner, and failed, knew that if it did not pay the tax, it would result in the whole-scale disconnection of telecoms in Jamaica, because the bulk of that tax was paid to Digicel. If Digicel didn't collect the tax, they would discontinue Cable and Wireless. The entire telecom system would have been completely destroyed. And we say this. This was said in evidence before the judges. So, my lords, they certainly took steps to mitigate.
My copy of the letter that starts on page 101, which is the detailed request of the Commissioner of Taxes,
Yes, my lord.
is, I'm afraid, largely illegible.
Oh, dear.
It may be that that's true of everybody's copy.
Yes.
It would help if I could have
Certainly, my
a
lord.
clearer copy, because that's the one where you say, as I understand it, you asked for the relevant information from the tax authorities.
That is so, my lord.
Yeah.
Pages 101 and 102.
But if we start from the proposition, which I think you do, that CWJ is the primary payer, has the primary liability to pay the tax,
Yes, my lord.
does it really matter what's going on, whether they knew or didn't know or could have found out whether Traille was also paying the tax in terms of what it was reasonable to do? I mean, they might have taken the view, well, we've got the primary obligation where we risk a penalty if we don't make sure the tax is paid. So in any event, might there not be an argument that that they acted perfectly reasonably, whether or not they knew the precise situation with the tax from Traille?
I certainly agree, my lord, that that would be the case. But they went over and beyond that to try and find out if it had been paid. And I suppose maybe efforts would have been made to get some sort of amelioration through Digicel and the revenue and so on. But the fact is that that didn't work. So they ended up right where they started with, which is the obligation to meet the tax.
There's a penalty of 15% if you don't pay.
There's a penalty of 15% if you don't pay. So, my lords, we say that the issue of mitigation does not arise. Now, I'm not so sure how much time I have left. Now, I believe my learned friend was in his last address, spoke about a windfall. And what was being argued, my lord, was that C&W, by turning on the switch, derived a benefit because it now was getting business from the client. But, my lords, they were providing a service.
Sorry?
They were providing a service.
Yes.
Cable and Wireless was providing a service which cost
They were getting a
Cable and-
contractual benefit.
They're getting a contractual benefit. Absolutely, my lord. So we refer to our submissions on this between paragraphs 113 to 116 on pages 1568 to 1569. And we accept the British Westinghouse case, but as the Court of Appeal found between paragraphs 159 to 162, that in the instant case, Cable and Wireless did not derive any windfall from the performance of the ICT. It should be the ICA, my lord. Performance of the ICA. It provided a service to Traille for which it was paid. Once a service is provided to Traille, there should be payment of the service charges.
But I suppose it could be said that if the injunction had not been granted, this piece of business wouldn't have been done, which may have been in net terms profitable to Cable and Wireless.
Well, my lord, what could be said, which I believe my learned friend adverted to, is that if the traffic had not been brought in by Traille, it would have been brought in perhaps to Cable and Wireless directly, or some other carrier, because these are calls that people are making from overseas. So, my lord, if Verizon, for argument's sake, wanted to bring in 1 million minutes in a month, and they had no public telephone service in Jamaica, they could not come to Jamaica and say, well, we're bringing in these $1 million of million minutes, and therefore we are going to pay our own tax. Although they cannot land those calls on any network because they don't have a telephone service. They don't have a public telephone service themselves. So, my lords, what perhaps would have happened is that those calls would have come in anyway. And I believe my learned friend was saying earlier that perhaps it was anti-competitive behavior. But the fact of the matter is that Cable and Wireless is required to interconnect, and it interconnects, and it merely seeks the appropriate payment for its services, plus the tax. They're not planning to keep the tax. They're giving it to the government who demands it. So, my lords, we say that there was no windfall, and therefore nothing that ought to have been considered otherwise by the court, the courts, both courts. So, my lords, we certainly are of the view that there were concurrent findings of fact by both courts. We therefore rely entirely on the dicta of this court in a number of cases which we have listed. The Gormandy decision.
Sorry, which issues are you relying on this for? Are you relying on it for everything in the case, or which particular issues are you saying?
There are concurrent findings.
Yes.
Certainly, my lord. So we are saying that there is a concurrent finding by my lord Batts and the Court of Appeal that Cable and Wireless was not in breach of the interconnection agreement.
But these aren't findings of pure fact.
I beg your pardon, my lord?
These aren't findings of pure fact.
They aren't findings of pure fact, my lord.
But that's all the concurrent findings jurisdiction is concerned with. At least these are evaluations, if not pure matters of law.
My lord, I do accept what your lordship is saying, but there are also findings of fact that there was no public telephone network, which Traille had in Jamaica. In order for Traille to be an applicable taxpayer, there had to be a finding that they operated a telephone service.
Yes, but these aren't in dispute, I don't think.
That they don't?
They're not disputing that CJW was not operating a public network.
Not that CDJ wasn't, and they did admit that they did not have one, but they were of the view that they were nevertheless entitled to.
Yes, I know, but that's not turning on a question of fact.
I agree, my lord. It is on a question of law.
Well, don't worry. I mean, I've now got the picture that it's not, you're not relying on it as an answer to every point raised. And
not
I think it's pretty obvious to us which are or are not findings of fact, to which
are findings of law.
Applies.
Certainly, my lord.
Yes.
And therefore, to the extent that your lordship should glean from our submissions that there are findings of fact which were determined in favor of Cable and Wireless, I would certainly say that in those circumstances, there should not be a varying from the decision of the courts below. If you could permit me one moment, please, my point. There was one of those, my lord, though, would well be the determination of fact as to the manner in which the tax should be computed in the interconnection agreement. So both courts found that applying the provisions of the interconnection agreement meant that the applicable tax should be included in the 3-month security deposit.
That is a point of construction.
That is a point of construction, my lord.
But what you haven't, I don't think, addressed us on, I may be wrong, and I apologize if I am wrong, is the status of TCT as an applicable tax for the purposes of clause 9.7. Is that,
Yes.
are you going to address us on that?
Well, my lord, we believe that it is patent that a telephone calls tax that is imposed on incoming international calls in relation to an agreement expressly entered into to permit Traille to bring in those international calls and land them on Cable and Wireless network or transit the network, that a tax which is charged on that traffic is an applicable tax for the purpose of this agreement.
Well, it's got to be a tax on the charges. So under clause 9.7, it's not a tax on the calls. It's a tax on the charges. So one can see it with VAT or general consumption tax, but that's clearly a tax on the value of the supply and therefore on the charge, and that is chargeable to the customer, and it has to be shown on what in this country is a VAT invoice, as I understand it is a GCT invoice. Now, I just want to be quite clear the basis on which you say that TCT is also an applicable tax. You see that the clause says any value added or other applicable tax.
Yes, my lord.
I mean, for example, in this country, there's something called insurance premium tax, which is not VAT, but if a policyholder pays a premium, they have to pay insurance premium tax on that, and that's shown in the premium invoice.
Yes, my lord.
So that I just wondered if you could address that. And I'm slightly puzzled, just while we're on it, on clause 9.7, by the words after the comma, where it's basically any value added or other applicable tax shall be paid by the party responsible for making such payment. It's not quite clear to me what such payment is referring back to, but it could be referring back to such tax or such tax being payable.
Yes, my lord.
So can you assist us on
Certainly,
this?
my lord. What we say is that this tax is in fact value added on the usage charges imposed for the service provided. It is therefore applicable in the circumstances of this contract and is payable by the contracting party who benefits from the service provided by Cable and Wireless. So this, my lord, is speaking about these parties, Cable and Wireless and Traille. And all that it is saying is that we have charged you as the terminating carrier for providing you services, and you are to pay value-added tax on those charges for that service.
Well, I mean, GCT is a value-added tax.
Yes, my lord.
And that, as I understand, I haven't seen any of the invoices, but I understood that GCT is shown as an additional charge on the invoices issued by Cable and Wireless.
Yes, my lord. And we do have copies of the invoices.
And that will show the GCT.
Yes, my lord.
It won't show the will it show the TCT?
It shows the TCT,
It does.
my lord.
Yes, of course it will do, won't it? I mean, if we have it might be worth just seeing one of those if you.
And in fact, the ones from Digicel are also there. So,
Well, if you want to just show, if it's in the bundle, it might just be helpful
yes, my
to
lord.
see one.
If I can just take you there quickly. So,
Mm-hmm. 6/5/2015.
Well, look, don't. Oh, sorry.
yes, my lord. I'm just having a little difficulty following all of them right now, my lord, but I'm getting there. So,
Well, I don't want to take up time. Maybe your junior can find one while
Can
you
find it
address
and-
us on
and-
anything
yes,
else
my
you
lord.
want to address us on.
certainly, my lord, I will do that.
So, just going back to the provisions of clause 9.7.
Yes, my lord.
The shall be paid by the party responsible for making such payment. What does that quite mean?
That would mean, my lord, the party who is receiving the service.
I see. Okay.
So if this interconnection agreement had provided for Cable and Wireless to get a service from Traille, for example,
Yes, I see. I understand.
then the party who is receiving the service is responsible to
Yeah.
pay the service charge and the tax on it.
Okay.
543. Look at the one at 5.
My lord, my Mr. Williams with me has suggested that we look at page 543.
So you see the billing period immediately?
Don't you address them.
No. Billing period.
My lord, if you are at page 543, you will see the billing period, 1st of March to the 1st of March.
Yes.
And you see the traffic period
Yes.
following.
And then all the tax element next come.
So, my lord, if you see the special tax, that item there under element,
Okay.
S tax, all the way down, my lord.
Yes.
And the head for it is international to mobile.
But to who's being invoiced under this invoice?
Traille, my lord. If you look at the top, you'll see Traille Caribbean is the.
So, but we don't, I mean, what we do see on page 544 is VAT 25%.
Yes, yes, my lord. The VAT or the GCT is a separate tax that is added.
Yes, that clearly is value-added tax for
Yes.
purposes of clause 9.7, I think.
But the special call tax is a separate item of tax, my lord.
Where do we see the figure for it?
That,
We've got the per minute rate, that's the tariff rate, isn't it?
yes, my lord. We see I believe that figure, my lord, I am a little bit stumped here.
Right.
I will have to look at it and I'll get back to you, but I do know that it's included in here.
Is there anything else you wanted to say about 9.7? I just had one other question on a different topic.
No, my lord, I would take your question now.
Just before lunch, you mentioned a statute governing OUR,
Yes,
which
my
you
lord.
suggested might be relevant to
That is so,
the
my lord.
determination OUR gave.
It's the Telecommunications Act, my lord.
Right, which we have, I think.
Yes, you do have it, my lord. And it is
1826.
page 1826. Thank you. Page 1826, my lord. References the amended Telecommunications Act. That amendment actually was 2012 too, my lord.
Right.
And if we look at the sections there, where is it? Let me find it.
Where would you like us to go?
I'm so sorry, my lord.
Looks as if it's
1826, you see the amendment to section 34. So it is amendment, section 18, which amends section 34, my lord. And
Subsection 6.
4, is it?
no.
Subsections.
Look for
It is the section, my lord, that deals with dispute resolution.
Well, in the middle of 826, there seems to be added to somewhere a new subsection 4, which says the office may, B, resolve post-contract disputes.
That
Is
is
that what
true.
you had in mind?
I believe that that was the very section that I was looking for, my
And
lord.
resolving such disputes, make such determination, and what, I don't,
So, my
Subsection
lord,
6
are
is
you
binding
able
on
to
the operator.
where is that, sorry?
Subsection 6.
Subsection
see
6.
subsection
Oh, yes,
4B, my lord?
I see, on the operator.
On the operator.
My lord, are you at page 1826?
Yes, I think we're looking at 1827, subsection 6, which says shall be binding on the operator.
Yes, my lord. So if, and of course, it deals with the resolving of post-contract disputes in B.
Where? What I'm not...
Who's the operator?
This is amending section 29 of the Principal Act, is it?
Yes, my lord.
We-
We have the Principal Act.
Right.
And what it did here was inserted that the office may, of its own initiative or at the request of a licensee, resolve disputes brought by a licensee before the office for resolution. So that is the 4 subparagraph B. And we do see in this provision that having come to a conclusion, there ought to have been a finality.
But binding on the operator in this context means cable and wireless, not someone with whom the operator is in contractual relations. And that's understandable because this is a regulatory provision designed to ensure that a potential monopolist plays the game properly when someone wants to make a telecommunications agreement with it.
Yes, my lord. So
So
this is,
in the context, I would read that as not merely an oversight that it doesn't say and the other contractual party, but quite deliberate.
yes, but my lord, in fact, that section that deals with it being binding on the operator is really treating with subparagraph 5, where it says when making a determination of an operator's
It says
interconnection charges.
It refers to 4. Subsection 6 refers to 4, subsection 4.
So
Yeah,
any determination the office made pursuant to subsection 4 shall be binding on the
Yes,
operator.
yeah.
So Well, we certainly say, my lord, that it was binding on both parties.
Thank you.
A licensee is also an operator.
I thought your case was that Traille isn't an operator.
No, our Traille does not have a public service, telephone service.
Okay.
But it certainly, my lord, is a licensee. And it was able to,
I mean, this argument doesn't, these provisions are not referred to, I think, in the judgments below, are they?
they are not, my lord.
It looks a bit like a new point.
It would, my lord.
All right.
What we do say is that there was an agreement between the parties as to how to treat with disputes. And it was invoked by Traille, and we participated, and a decision was made.
Yeah, I follow.
My lord, unless there's anything else that I can assist the court with.
No, thank you very much, Ms. Kitson. Now, Dr. Barnett.
Please, my lord. On that matter which has just been raised in respect of the determination or any determination by the OUR, whilst it might act on its own initiative in the interests of stability in the telecommunications industry or any of the other utilities that it monitors, it can't make a decision without giving an opportunity to both parties to make submissions. So that if it raises a matter on its own initiative, by normal general principles as well as the provisions of the act under which it operates, it has to observe the principles of fairness, so that any decision it made in relation to who had the liability to pay the TCT, which was not what was submitted to it, would have had to have that preliminary procedural safeguard complied with first. On the question of the extent to which Traille sought the determination of the OUR, this was quite specific, my lords, because this was done from the 17th of April. And if you look at E510, you will see where that request was made. And the response from the OUR which was in part based upon the technical note which your lordships have already examined. It made reference to who had the responsibility to pay over the tax at page 5, 16 to 18. But that was not what was referred to them at that time. And the conclusion that they stated in that response relates to the specific question of the inclusion of the PCT in the deposit. But at the same time, the tax authority themselves said it was not clear and had to be referred to their legal team. And this is at E5 Ward 9. And I'm a little surprised because it was agreed by both parties that Traille offered to comply with the OUR's determination that the TCT should be included in the deposit, and sought a recalculation of the figure from CWJ as to how much they should pay. And the parties have agreed, and you'll find that at page 524, that there was a new dispute in which Traille was insisting that it had the liability to pay the TCT, which is not disputed. And the only question is whether they had to pay it by a roundabout method of paying it to CWJ at first, for CWJ to pay it on to the tax collectorate. And my lords, the position is quite clear that the TCT is not a value-added tax, but a charge on a per-minute basis, irrespective of what the customer has been charged. And I refer you, ask your lordship also to look at the receipt agreed by the parties, paragraph 4 at page E. Tutu. 1493. And the SFI paragraph at page 1500. Paragraph 7 at page 1800. In respect of your lordship's question as to whether there was any requirement for a pleading, and to which I had answered that there was no requirement as to pleading in respect of the damages, but I had said that the rules of fairness requires that notice should be given to the party before the hearing on the assessment of damages as to what is the basis of the claim. There's actually provision in our civil procedure rules relating to assessments, and this is in 16.4, which is not in the bungle, but which we can make available, which outlines the requirements. And there was also an order made by the court for the service by the parties of witness statements and production of documents in anticipation of the holding of the inquiry as to damages. On the 27th, on that page 1502, where the parties agreed on the issues which were brought to the Court of Appeal by Lords. The 7th issue listed, although the injunction was granted before any dispute arose as to who should pay the TCT, it was the cause of the losses claimed to have been suffered by CWG. So that, my lords, their position is that the...
Dr. Barnett,
Yes.
there's a footnote which says that actually the respondent doesn't agree with the words before any dispute arose, but thinks it was before that dispute was determined.
And they prefer a determination there.
Yes.
Yes. Which
It's one of
I
those.
respectfully submit does not it's probably straightens the point I'm making rather than removes it. Well, my lords, okay. Those would be my submissions in response.
Thank you. Yeah, well, yes.
I do beg your pardon, my lord. We were able to find the documents that your lordship asked for. And they can be, if I could just point them out, pages 570 to 558. I beg your pardon.
570 to 580. Is that right?
My lord, 580. Those are the statements of account from Lime to Traille, which indicate the tax.
Thank you very much.
Obliged, my lord.
Thank you.
Excellent.
Well, we're most grateful to advocates on both sides, those who've spoken and those who've been involved in what's clearly been some very thorough preparation, for your careful and helpful submissions. And as will come as no surprise, the board will take time to consider what advice to tender to His Majesty.